was a hot bench, but it wasn't as hot a bench as Judge Breyer, where you really
Right.
knew where it was going, where they're going to come down. They vigorously questioned both sides here. So my predictive powers here are I'm without it. I don't know where they're going to land, but I will say the most important thing about this hearing to me, and you touched on it, Harry, it's about the radicalism of the Trump administration's position was cast into very sharp relief during questioning by one of the Trump appointed judges, Judge Bennett, had asked Brett Shumate, an assistant attorney general arguing on behalf of the Trump administration, saying, let's say there was civil unrest localized to California. Can a president, and he posited a hypothetical future president, but can a president take those set of facts and send in the National Guard in all 50 states and the District of Columbia without any court being able to review it? Without hesitation, Brett Shumate's response, yes, it would be an express delegation, and that would mean that it's an unreviewable power. So at
And
that
let me just
moment,
keep it because there were more extreme hypotheticals. I think maybe the most extreme was we saw the Breyer article, and I read the Breyer. I wrote about the Breyer article and its finding that it's to the judiciary to say whether there's a rebellion. Not only did the Trump administration not endorse that view, not only did they say Trump can characterize a rebellion whenever he sees one, I believe they were asked, and is this right? This is through news reports. Does it even have to be a rebellion or one of the three predicate situations in the statute? Let's say Trump says, I'm invoking this statute because it's Tuesday. Is there anything the judiciary can do? And Shoemate, if I hear right, just said, nope. If he just says the words of that statute, the judiciary has to stand down. Correct?
you have it exactly right, Harry. And that goes to the hypothetical that I just mentioned, because remember, he's not saying, is there a rebellion in all 50 states and the District of Columbia? He's saying,
Right.
assume there's an unrest in California. Can the President of the United States call in the troops, essentially, to all 50 states and the District of Columbia, and the courts can't do anything about it? Yes, without hesitation, that's the Trump administration's position on this, and it couldn't get more radical than that.
All right, and there's a certain awkwardness here because normally Breyer speaks to this, and should this be a situation in which you do have that kind of deference? But doctrines of deference really assume a kind of good faith on the part of the executive, and more courts. It happened today in with a Reagan judge back east saying this is terrible racist stuff. More and more courts are looking in the eye at what, is just an objective fact here, which is the honesty and good faith and bona fides of this administration has to be in question. So if you provide Trump the power to simply call a rebellion whatever he feels like. The Nationals are losing the baseball seat. Whatever he says is a rebellion. It is a rebellion. If you overlay that with his general track record of, I'm sorry, just to put it out there as a fact, lying all the time, it essentially gives rise to an all-encompassing and unreviewable power. Was there any discussion at any time about the need for the president to be honest, the good faith of the president, or to the extent they were entertaining deference, were they just doing it without regard to the particular president and the particular possibility of an outlandish and false supposition on his part?
Right. There didn't seem to be anything suggesting an interest in whether the government needed to show any good faith, that the courts weren't really going to look into that. That seemed to be a kind of unremarked upon issue throughout the throughout the hearing, excuse me.
Mhm.
What I will say is that there seemed to be skepticism by the Trump appointees. They kept saying during the assertion of an unreviewable power, well, suppose you're wrong about that. And
Right.
the first time they say, that could just be a discursive thing that judges say. But both Judge Miller and Judge Bennett, the Trump appointees, kept returning to that hypothetical where it sounded like maybe that's not a hypothetical anymore. So even if they rule in the Trump administration's favor, are they going to endorse this maximalist view
Yeah.
that anything any president says in justification, if I call it a rebellion, then it is so?
Yeah.
I don't know if, based on what I heard, this court is willing to go that far.
All right, and you would think they at least have it in mind. And for what it's worth, I'm loath generally to just characterize judges according to who appointed them. But I have gone to school a little bit on these two Trump appointees, and they are not in the Eileen Cannon or James Ho kind of mold of really Trump can do no wrong. They have certain professional bona fides, though obviously they couldn't have been chosen if they didn't give confidence to the White House that they're going to be there when the chips are down. All right. Most of the reports, Adam, suggest that the California attorney had something of a rough time. Tell us a little bit about the questioning that he faced.
So I would say that some of the most vigorous questioning came from the one Biden appointee on the panel, Judge Sung, who was grappling with certain precedents
Yeah.
involving the limitations of court review. Now, whether Judge Sung was asking those questions because she wanted to clarify her own ruling to resolve certain questions, that she needs to resolve to get to the other end. We don't know. We don't know the purpose of that questioning. But I would say that was true on both sides, where you had the Trump appointees were the people most vigorously questioning the Department of Justice here, especially on the assertions of executive power. But you heard it exactly right. The reports have it correct that California Assistant Attorney General here did not have an easy reception. He certainly had a hot bench. There wasn't this sort of situation that we got in the lower court with Judge Breyer, where Judge Breyer was clearly, before he issued his ruling, everyone knew he was going to rule against the Trump administration. Here we have a three-judge panel that wasn't tipping its hand, that doesn't seem to be alarmed by the assertion of executive power here, the way Judge Breyer was, the way Judge
Mhm.
Breyer kept comparing this more befitting of King George than a constitutional democracy was one of the lines that he had right before No King's Day, invoking a monarchical rule. That didn't happen today. Here it was the government got some tough questioning, and the California Attorney General's office got some really tough questioning. I really
Okay, and
wouldn't know
on
where to
that,
call it.
it seemed to be that the California AAG had to grapple with like an 1805 Supreme Court precedent. Yes, that that the Biden judge really had gone to school on different doctrines of non-reviewability or deference to executive determinations, especially in certain areas of national security, foreign policy, and the like. Yeah.
Right, right. And that was one of the things that the California Attorney General's office responded. The AAG said something along the lines of it that because it's such an old precedent, so much has changed since then. And Judge Sung said, "Well, we may be bound by that anyway, in sum and substance." So that that is something that we could see impacting this decision, and then it could be up to the Supreme Court to see whether that 19th century precedent is controlling and stands, or whether it like other precedents that they have overturned. in recent years is up for an update, is up for a
Yeah,
review.
and it's a good point. This is likely to go to the court. It's likely to go under some kind of emergency setting. As we're talking, the events are unfolding on the ground. Now, let me just move to those for a second because Breyer advanced that change that's happening to actually say, I am keeping this case. So we have a strange state of affairs. Typically, the Court of Appeals just takes a case over and the district court waits for instruction. But what Breyer did in that opinion, and just as a matter of judicial workmanship, pretty remarkable. Very quick briefing schedule. Very quick hearing, and just goes into his chambers and pounds out 36 pages. But he puts the most tentative temporary restraining order on what's happening in LA. We don't have to get into the fine points of it, but that's a generally controversial thing for a court of appeals to lift. And then in the meantime, things are changing already on the ground. So Breyer has said, I have a hearing for a preliminary injunction scheduled for this Friday. All the Court of Appeals has done is stay my initial temporary restraining order. You know what? I'm going ahead because it's a different thing and there are different facts. So I don't know if that came up, Adam, because one would expect the Ninth Circuit, or at least the Ninth Circuit, to consider uh, amending its order where they've stayed what Breyer did initially and saying, forget about the Friday hearing, just be cool, Judge Breyer, and wait for us to issue our opinion. Did that come out at all? And I know it's hard to predict what they do bottom line, but do you have a sense of whether they will actually permit this dual district court and court of appeals proceedings to continue?